Welcome back to the Conduct Detrimental Podcast. Today's another edition of our sports law roundup. We had our first last month, and what we try to do for this episode is take a look at a few of the sports legal cases, issues over the past month that we haven't had a chance to dive into deeply, and kind of do an around the horn version. Today I think we have 4 or 5 that we're going to hit. We're planning on hitting, so without further ado, I'm Dan Worley. I'm joined by my co-host Dan Wallach. Dan, how's everything going today?
Everything's going well. The roundup is kind of our default when we can't come up with a guest. So I enjoy doing the roundup just to go around the horn. We don't get an opportunity to do that when we have a guest on the mic, and we have to focus most of our conversation around the subject that we brought the guest on to speak about. So I'm excited to kind of get back into the the whole mix of everything that's been out there that we haven't been able to address outside of Twitter. And I'm also, I can't believe we're 10 episodes into Conduct. Is it 10 or is it less? I think it's 10.
Yeah, this is our 10th. So
that blows my mind. I mean, I remember it was just yesterday. I didn't even know what a USB mic was. I had no idea how this process worked, and I probably still don't know that much about it. But it's just daunting to me that we're now into double digits, and hopefully triple digits by some point in late 2017, 2018. And we got one more to go this year. This is our penultimate episode. I think we're going to do a year and, the whole year in review at some point next week. So we're going to finish strongly here.
Absolutely. And everyone keep an eye out for that. And I think we had one of our highlight episodes, which we put up over last weekend, and that was just kind of a Deflategate review with Bob McGovern from the Boston Herald, who was just fantastic. He's a really interesting guy and had a lot of interesting perspective.
He's got the most awesome voice for radio. He's a nice looking guy. I'm not saying he's got a voice for radio, but he's got a set of pipes on him. He'd be great for doing like radio voiceovers or just hosting a radio show.
Yeah.
I've always told him that. I just love the way his voice sounds.
Got a little accent to it, a little East Coast, So
yeah. A Bostonian from Brooklyn.
Right. Well, let's get going with the roundup, and I think the first one that there's a lot going on right now. We've seen a lot of really high-profile cases and disputes. So I think one of them, the biggest one potentially, is this Joe Mixon case, and it's something that's been talked about over the last year or two, because the incident happened a few years ago. But it was kind of in the back pages, not really in the focus. And then now all of a sudden, of course, we have sort of a Ray Rice part 2. We have a video come out, and that really raised the profile of this case. There's this sort of on the side, what people aren't really paying attention to is this giant legal battle that's going on over this video and over the case in general. And I know, Dan, you've dug into that pretty deep. I mean, can you kind of explain the procedure of what's going on and how that looks right now?
Yeah, the incident in question took place at a bar called Pickleman's. Great name for a bar. Back in 2014, there was an altercation between Joe Mixon, who is a star running back for the University of Oklahoma, and he's set to be eligible for the NFL draft in 2017. He broke a woman's jaw and cheekbone with one punch. And that's old news. He was suspended from the program for 1 year as a result of that, and had criminal charges for which he pleaded, I think, no contest, did some community service, was on probation. All that took place 2 years ago. But in this internet, social media age, it's like it doesn't even matter unless there's video. And fast forward to 2016, the criminal investigation in Norman, Oklahoma had completed. He pleaded no contest, but news organizations wanted to get a copy of the video, and apparently some select members of the media viewed the videotape while it was in the custody of the Norman County Sheriff's Office. And those limited number of people who saw it said that it was worse than the Ray Rice videotape, that if this ever came out, it would blow up, become a national story. So several news organizations filed suit against the city of Norman, the Norman County Sheriff's Office, the city, all the municipal organizations that had, control or custody or decision-making ability. And it went all the way up to the Oklahoma Supreme Court. And several weeks ago, the Oklahoma Supreme Court, in a fairly lengthy opinion, and a concurring opinion, no less, ruled that the videotape was a matter. There were two videotapes. The court case only addressed one of the videos, and the Supreme Court found that it was a matter of public record. This was a decision on December 6th, and that the sheriff's office had to release the videotape to the various news organizations. Well, what happens in the interim is that the court appeal is not final until, as you know, and we all appellate lawyers may understand, there's a mandate that has to issue, which allows a period of time for the losing side to file a petition for rehearing. Well, the mandate wasn't going to issue until December 26th, and what happened about a week ago is that Joe Mixon's lawyers released not just the one videotape, but both videotapes. And the irony of this was that it was the suspect or the assailant that wanted the videos released, but the victim did not. And once these videotapes got released, Joe Mixon became a national household sports law name because it's far worse than anything we saw in the Ray Rice video. One solid punch that just knocked the woman, to the ground, and it took her a while to become stabilized again. She kept trying to get up and was woozy and was falling down. And what did Joe Mixon do in the interim? He didn't stand by to help her or go, oh my God, what did I just do? He left the scene without any care in the world. So now the sound you hear is Joe Mixon's NFL draft stock plummeting from what is likely a first-round talent to maybe third round, fourth round, or potentially not even in the draft. I think somebody's going to take him. He's super talented. He can help so many teams currently, and given the renaissance of the running back position, I think he's still a high draft pick. Anyway, I didn't mean to go on and cut you off there, but that's where we are today with the Joe Mixon videotape.
Yeah, I disagree with the draft stock. I think he was potentially a first-round pick and the talent's there, but I think teams are becoming more educated on these issues. I think would be a huge blowback by a fan base, rightfully so, that the team, or maybe rightfully so, that the team drafted him. And I just don't see a team taking a risk, especially in a draft like this year where there's so much talent at running back. There's three.
Is there?
Yeah, we have Leonard Fournette, we have the Florida State running back, and some others. So. Mixon was in that mix, if you will, for the tier after those guys, and I just don't see a team touch him. I mean, maybe he gets a tryout. I would assume he's going to get a chance at some point. I just don't see him getting drafted just because of a PR angle. Another thing that I found really curious, and you talked about it a second ago, was him and his lawyer's decision to release this before they were required to. And I found that curious, and then you kind of do a little bit more digging and think about it. They released it on a Friday night or a Friday afternoon, which is notorious for, media news stories to come out where they don't want to attract a lot of attention. Well, guess what? When you release a video like this, it's going to get a lot of attention no matter what you do. But also the decision to do so on their own terms. They issued, I think, an apology through the school, and it was just a fascinating legal. I mean, what did you think from that legal perspective of how that all came to pass?
Well, I think he wanted to avoid what happened at a bowl game 2 years ago, where he was only questioned about the assault and about the accusations. I think to eliminate the distraction in mid-December. Good luck with that, by the way. It's not, because it's not going away. But better to address it on your own terms than have it become an emerging news story during the week of a bowl game or in the run up to the NFL draft. Now here we are, several months away from the combine, even longer away from the draft. He can be coached up into rehabilitating his personality, rehabilitating his character, so to speak. And, in the months coming up, if he, shows contrition and conducts himself well in the interviews with, NFL officials and team officials, I'm not so certain that given his talent level, he's going to fall out of the draft entirely. I mean, the Kansas City Chiefs had a similar situation a year ago where they drafted a character risk in the 5th round, and they had to deal with a significant PR hit, and now they've got the Rookie of the Year. So, at the end,
Ezekiel Elliott might disagree with that Rookie of the Year, but he's very good. He's very good.
AFC Rookie of the Year.
Hill is very good.
One of the best players in the draft.
Absolutely, and certainly an equally disturbing case, albeit more under the radar. There wasn't as much talk about that in the mainstream media. There wasn't a video. The allegations are maybe even more horrifying. In that case, Hill was alleged to, and I don't know too many of the details, but he had a pregnant girlfriend at the time and punched her, including punching her in the stomach while she was pregnant, which is just horrifying.
Yeah,
but,
on a scale of 1 to 10, that's like a 14.
Right.
I mean, that's far worse.
But I do think that's a good comparison. But again, the only difference is we're in the age where Greg Hardy gets a second chance. He didn't have a video attached, and Ray Rice, who did have a video attached, didn't get a second chance. So I don't know if that's the determining factor. I think it'll be an interesting storyline to keep an eye on moving forward.
Yeah, he's just so good, though. These coaches and general managers, I mean, they're on a very short, there's no such thing as a 5-year rebuilding program anymore. There's pressure to win now early. Looking at Rex Ryan, who is going to be 2 and out very soon. General managers and coaches aren't on as long of a string as they used to, when you could mollify a fan base with, this is a rebuilding program. It's like the time is now. And he's just such a special player at a position that's becoming in vogue again. And if he can help a team win, and I think he can, based on what I've seen on film, and his statistics, don't lie. This is a first-round talent that if he drops to somebody in the 4th or 5th round, you've got 32 NFL teams that have to pass on him. And I would be surprised if he gets out of, the early rounds, even with all that baggage. And to his credit, he had no choice, but he addressed that this is a matter and an urgency that was addressed way before the NFL draft. What did Ray Rice in wasn't necessarily anything that he did wrong, but the NFL underpunished him. And then the video emerges, and that becomes the equivalent of like a cause for banishment. And it wasn't his fault that the video emerged. It was the league's failure to investigate properly and insist upon, this kind of evidence before making a final decision. All this stuff is known about Joe Mixon, and as long as there are no surprises between now and April of 2017, I say he's still draftable.
Yeah, the parallels to the two cases are fascinating because, obviously the video comes out a period of time later in both cases. When Oklahoma suspended Mixon for a year, they did note that they saw the video. They knew it was on the video at least. I can't remember if they saw it or at least knew it was on the video, so they admitted to that. And there's been quite a bit of blowback against Oklahoma saying that this 1-year suspension was insufficient and he really should have been suspended more. Which is a similar argument to what we heard after the Ray Rice video came out.
Yeah, it's funny. Dan, just yesterday, Bob Stoops was asked about that, and he said if this had occurred in 2016, he would dismiss Joe Mixon from the team, not suspend him, dismiss him, gone for good. So
I think that's kind of BS. I mean, I don't think that everything's changed so much in the last 2 years that this dynamic has changed. I'm hoping that that's a sign of awareness in the community and in the NCAA community of abuse towards women. But at the same time, I just don't buy it. It's only 2 years. If he really feels that it should have been that way now, he should have felt that it was the same way just 2 years ago. But I'll get off my soapbox now.
The irony of it is, we have a victim here, named Angela Molitor, who didn't want the her name is public. It's not a sex assault case, but there was an altercation between the two of them. I mean, she did nothing to deserve being punched in the face, but some of her conduct came into question as to whether she might have initiated the confrontation by pushing him, slapping him in the face. He had originally accused her of using racial epithets against him, although he walked that back a short time ago. So this is a difficult case, and it's probably not helped much by his reputation of being somewhat of a hothead. He was a terrible interview during the Orange Bowl game a couple of years ago. Seemed somewhat short-tempered, and that, just as much as a videotape, could prove his undoing because, going forward, teams have to be cognizant not only of a player's injury history, but of a player's suspendability based upon, past, incidents of domestic violence or crimes or assaults. I mean, the NFL has clamped down in their personal conduct policy, and if there's not zero tolerance, there's barely more than that. You might get one chance, but you could be drummed out of the league if there's a player that has a recurring, anger problem, a violence problem. If it's not through a suspension, it will be through a hands-off. Nobody will touch him. And that's going to be his biggest, foe going forward is whether this is a one-time anomaly or whether this is a pattern of conduct that teams are going to have to watch out for. And if they believe that he's incapable of keeping his anger under control, maybe you're right. Maybe he's not worth a draft pick anywhere near the top 5 rounds.
Yeah, I think it's a great point. And I think some of those later details that have leaked, NFL teams will take into consideration in evaluating his character. For example, when he initially says that she said racial slurs to him and that's why he hit her, and then you see the video of him, they had it on Outside the Lines today, of him in the interrogation room saying that she hit him so hard he didn't even know it hit him, and you watch the video and she pushes him pretty good, but I don't think his reaction to a push like that was commensurate with how he was pushed. She didn't hit him nearly as hard as he hit her, obviously. And so when you hear some of these, maybe excuses is the wrong word, but details come out of him not saying things that are truthful and making excuses for himself, I think that also goes to the determination when you're in the draft room and really evaluating whether this player made one mistake or whether this is going to be a serious risk moving forward. And again, I just think that with the climate of the NFL is right now, I think it's a stretch to think that he'll be drafted early on or at all. Yeah.
And until his first 100-yard game. But there's absolutely no mitigating factor on that videotape. As hard as she might have pushed him, and she didn't push him that hard, his response was, as you correctly point out, disproportionate. But what bothered me the most was that he just left afterwards. He expressed no concern, didn't try to help her up, didn't say, "Oh my God, what have I done? Are you okay?" He showed a stunning and galling lack of concern for another human being that he seriously injured, and left in a state of, if she wasn't unconscious, she was severely hurt, and he expressed no remorse or attempt to, try to help her. And that bothered me more than anything. And that shows a lack of character. But again, we're not drafting players to be stand-up people and great citizens. The question is his conduct, is he going to cross the line again? And if teams don't get a good read on him, then they're not going to draft him.
Yeah. One last point I just want to touch on before we move on. I don't think he's in position to be suspended by the NFL, although we have seen players who get in trouble with the NCAA ultimately be suspended by the NFL. That was Terrell Pryor was the most noteworthy case there. But I think that this happened so long ago. He was already punished. I don't think we'll see another punish by Oklahoma. So this will be purely a image hit at this point. And I know you've actually, so the victim here actually filed a civil lawsuit as well. We haven't talked about that yet.
And she missed the statute of limitations on a battery claim. You realize that in Oklahoma, there's a 1-year statute of limitations for battery. She waited 2 years before filing suit, and then tried to file the lawsuit in San Francisco. of all places. Maybe there's a longer statute of limitations for battery claims. Anyway, the case gets transferred back to San Francisco, back to Oklahoma, and several weeks back, it's in federal court in Norman, Oklahoma. She filed a 3-count complaint, and the judge dismissed 2 out of the 3 counts with leave to amend, and the only surviving count, and in fact, she has waived any right to amend because the amendment deadline has passed. So for a shot like that, that could be worth a lot of money, her only cause of action is intentional infliction of emotional distress for just a simple assault. So she may not get any money out of him based upon when she filed suit and the theories under which she is traveling. My immediate reaction to an incident like that is, well, if you're going to retain counsel, file suit before the deadline expires and bring a battery claim, and then leverage it for a valuable settlement at some point down the road. And now I think she's lost all of the leverage.
Yeah, exactly. I have to just imagine that she just didn't talk to a lawyer over those 2 years, and that aspect hadn't really come across her brain, and it's unfortunate for her because that is a pretty tight statute of limitations. I've seen it longer in other states. So, but definitely probably a case to keep an eye on. And IIED doesn't fit quite as cleanly as a battery or civil battery claim, but at the same time, I think it's still possible. And if you get in front of a jury on that, and they look at the possible damages and say, well, this is pretty bad, and that video is playing, and so we'll see.
You have to show extreme or outrageous conduct, and this may very well qualify.
Yeah, absolutely. So let's move on to the next case we want to talk to, and that's another fight case. I guess that's the theme of this month. There's a lot of college issues and a lot of fighting happening. This is a professional athlete case, and that is the incident that occurred with Matt Barnes and DeMarcus Cousins at a nightclub in New York. I guess this was 3 or 4 weeks ago now, and the details, the facts are foggy. There's multiple sides to the story. The accusers say that basically Matt Barnes came out of nowhere and began choking a woman at the bar, and then elbowed her in the head, which basically knocked her unconscious. And then DeMarcus Cousins came over when some other guy was charging at Matt Barnes, began punching him, and then him and Barnes both kind of beat this guy up while he was on the floor, and then fled the bar. No criminal charges have been pressed as of yet.
Against them.
Correct. Against them. We'll get to that other part in a minute. They left the scene. There's a interesting video taken outside of the bar. I don't know how people record everything these days, but there's a conversation, about a 90-second conversation between Cousins and some of the other people in their group, and they're discussing what happened in there, and he kind of is bragging about how he slugged this guy in the face, and within a week, those two filed a civil lawsuit against Barnes and Cousins, again in federal court in New York, alleging battery claims. I think they also have a intentional infliction of emotional distress or some other claim on there as well. I can't remember specifically.
Prima facie tort.
Right.
How happy are you that things get filed in federal court? I mean, it's the difference between knowing what's happening in the case and being beholden to others reporting. I mean, once something is filed in a federal court docket because of the PACER subscription plan, we get simultaneous or instant access to court filed documents the moment they are filed.
Exactly, and so that's the difference between state and federal court. Some states have a pretty good electronic docket now, but it's usually a little bit difficult to get access if you're not practicing in that state. So as lawyers, Dan and I both, as you mentioned, can have access to federal dockets and appellate dockets and Supreme Court, some of the Supreme Court dockets. And so that's great because we're basically up to the minute with everybody else in the case, the lawyers in the case. And it's also nice because I are both more familiar with some of the procedural laws that govern all federal cases, as opposed to state by state. Each state has their different laws that govern the procedural and also the substantive law behind each of the claims.
Yeah, I mean, I'll take you one further. I think it gives us an advantage over the mainstream press because we have PACER accounts and most of them don't. And it creates a value when you follow a case, especially if you're familiar with deadlines and when to expect documents to be filed. So, because of our, background as litigators and appellate lawyers, we have like a sixth sense about when something might be filed. And of course, once a case is on our radar, we can continually, monitor it for new developments. And as we're doing in the Matt Barnes case, but I think this case is going to become reach a higher profile once the two players, or at least one of the two players, is arrested. I mean, I can't imagine that, these players threw punches and there were black eyes and there's photographic evidence. I'm wondering why so long to, have an arrest announced. I mean, we know where they are. They're in Sacramento, so I would expect the next shoe to drop pretty quickly.
Right, and we didn't get to it, but we mentioned that there was an arrest made of a woman who allegedly, at least, was in the Cousins Barnes group. And so she was arrested for apparently hitting another woman.
Oh, she beat up two women.
Bodyguard, maybe. I don't know. But so one arrest has been made. We don't have any confirmation or denial whether Barnes or Cousins will be arrested. The investigation apparently is ongoing, so we're just going to have to wait and see on that front. Mm-hmm. On the civil side, we've seen the plaintiffs' lawyers sort of release pictures. They had a press conference. There was pictures of the guy whose face was bruised and swollen, looked pretty bad. They had a pretty compelling narrative in their lawsuit, which certainly doesn't tell both sides of the story, but whether or not it's actionable remains to be seen. We're going to, depending on when Cousins and Barnes were served with the suit, which we don't know that exact date, but we're expecting their response sometimes toward the end of this month. I think starting on the 27th, in that range, their response will be due, and they can either move to dismiss the suit or answer, which will be a straight denial. I expect them to have a self-defense to it because they've already come out and said that. But who knows?
Yes, 6'11" DeMarcus Cousins acted in self-defense against two people that were barely, if at all, 6 feet.
Yeah, I think
and I think the response might be to, try to move to dismiss it. But when you're talking about a simple assault and a personal injury, I don't think this is susceptible to a motion to dismiss, and maybe not even a motion for summary judgment. I wouldn't be surprised to just see a straight answer to the complaint. I mean, on what ground could you move to dismiss? I mean, they were within the jurisdiction of New York. They were in New York County, so it's the right venue. You got photographic evidence, and it's an assault and battery. So I'm not quite certain where the arguments are going to come to support a Rule 12b-6 motion to dismiss, which is an early stage dismissal motion asserting to the court that even if all the facts are true, it doesn't state a viable legal theory or legal cause of action. So this might just continue on to discovery, and I would think Cousins and Barnes, if they're both served with process and respond to the complaint, that they're gonna file answers rather than MTDs.
That's probably right. I'd have to dig into it more to see if there's any grounds for a motion to dismiss. But when I read it, nothing came to my mind either. As you mentioned, just to keep everyone in the loop, you said this, but really what a motion to dismiss is saying, listen, even assuming everything in a plaintiff's motion to dismiss is true, it's correct, even that doesn't violate this, the law out there. And so they can say whatever they want essentially in a complaint, and I think they said enough to get past the motion to dismiss. And I think, as you noted as well, that this will come to a head on summary judgment, and if the plaintiffs can get past summary judgment, which we'll have to wait and see what the evidence of the case is, this could be a case that either goes to trial or settles sometimes between those two stages would be probably the two most likely outcomes. at this point.
Yeah, I would agree with that. I mean, at what stage, Dan, do you think this becomes a matter for NBA discipline? Because I think the real leverage that the plaintiffs have is, the discovery process, depositions, the continuation of the criminal case. If Cousins and Barnes can make this all go away, it would probably limit their risk with the NBA disciplinary process. But at some point, if this goes on and they're charged, the civil case proceeds, at what point does the NBA get involved? Is it after a conviction or maybe earlier?
I think to me it all depends on the criminal charges, how that goes. If they get charged, they plead guilty or whatever it may be, whatever happens, then we could see some discipline. I think if charges aren't pressed and this is only a civil case, I find it highly unlikely, unless something really bad comes out, that they would get suspended. The NBA doesn't have a history of suspending. I looked this up during the Derrick Rose case because that was a civil trial. I couldn't find any suspension that was based solely off of a civil lawsuit. So I think that as long as the criminal investigation doesn't lead to anything, they're probably in the clear from the NBA perspective. Although, we've seen sort of the model of player discipline over the last few years change. Adam Silver, I would argue, certainly has the power to suspend them. He just hasn't shown the desire to do so for civil cases in the past. But that's, he's still relatively new. And, I don't know if the player discipline, it may come into they're adding a new domestic violence policy to the CBA, and depending on how broad that is, this is Matt Barnes hitting a woman. I don't know if that classifies as domestic violence per se, but it's certainly a terrible look one way or the other. So that'll be an interesting issue. I just don't see it at this point. But again, this is something that we're just going to have to kind of wait and see. And I think the big piece of evidence here is the surveillance tape within the bar itself. And at this point, we've had sort of mixed reports. By one saying that both say that there is a tape. One says it's so blurry and it was so far away you couldn't tell at all what happened, and the other report says it looks like Barnes initiated things. So it'll depend what happens with that. I am on the same page as you, but I don't know what the heck the NYPD is doing at this point, why it's taking so long, or I'm sure we're just in the dark about all the details of that investigation. But
it's funny you ask. I called up the press bureau of the NYPD last week and asked that very question, when they're going to announce it. And he goes, "Well, we don't announce when warrants get issued. We'll announce an arrest. Prior to that point, we don't give status updates." So with Barnes and Cousins playing for a team that plays half the year in California and may travel to other states, getting an arrest or effectuating an arrest, may, if that's the direction that the NYPD is going, it may take a while.
That's interesting.
It may take a while. And when I'm thinking of NBA discipline, it's not Matt Barnes I'm asking about. It's more DeMarcus Cousins, because Matt Barnes will probably be out of the league after this year. I mean, he's had a very long career and has had disciplinary issues, not just with every team, but every year with every team. And by the time this emerges into an adjudication, or there's on the criminal side or the civil side, I don't think Matt Barnes would have much of a viable career left anyway. It's DeMarcus Cousins who now is sort of at the center of a storm of so much controversy. The incident that they had last week, the threatening incident with the Sacramento beat reporter, this disciplinary issues going beyond that, and as a player who's earning one of the highest annual salaries in the NBA, he's going to put that at risk if he doesn't try to resolve this civil case amicably. I mean, this can only get worse for him if he's arrested, or his discovery or depositions leading to a judgment against him in the case. It may be in his best interest in terms of crisis management to nip this in the bud early and try to reach an out-of-court settlement, even if he's not arrested, to reach an out-of-court settlement with the victims that impact his wallet much less than if it were to blow up and become a civil judgment followed by NBA disciplinary action. So DeMarcus Cousins doesn't need this. This is a case he could probably settle in the six figures right now.
Yeah, it's an interesting question. And I think another interesting angle is that Barnes and Cousins lawyers, a guy named Alex Spiro, who's out of New York, who is sort of building a niche defending players, most notably Thabo Sefolosha in his criminal case when he was charged with an incident in a New York nightclub again, ultimately found not guilty, and now he has a civil case against the NYPD for use of excessive violence against him. And I think, and I don't know, what the dynamic of that relationship was, but you saw Sefolosha take a very aggressive stance in that case. He was offered a plea bargain that would have essentially been almost nothing. It was very minimal community service, and they would drop the charges completely. Instead, he risked jail time and took it to trial, ultimately won the case. Great for him. But you see a pattern, and I don't know if that's his attorney, who's the same attorney here, saying, let's take an aggressive path on this, or whether that was Sefolosha himself saying, I want to stand up for this, which very well could have happened. But, I think the attorney angle, Spiro, by all accounts, is a very good attorney, but seems to be an aggressive guy, and he could take a similar stance in this case.
That's a really interesting point. I tend to see a lot of the same lawyers surfacing in these professional athlete cases. Matt Barnes had a civil lawyer in the New York civil assault case. It was only filed 2 weeks ago, but he hired a lawyer by the name of Kevin Fritz, who also happens to represent Jason Pierre-Paul in JPP's invasion of privacy lawsuit against Adam Schefter and ESPN, and that lawsuit is pending in Florida federal court. Well, Kevin, who's a New York-based lawyer, was retained by Matt Barnes, and he filed a notice of appearance yesterday. And guess what? A day later, Kevin filed a request to withdraw from representing Mr. Barnes because he hadn't been paid. This is someone who filed the appearance yesterday, and a day later seeks to get out of the case because of financial considerations, and that Barnes signed an engagement agreement 2 weeks ago and has yet to pay his attorney. So it's kind of interesting to see many of these same lawyers, all very talented lawyers with good firms, and but have somehow built a professional athlete practice within their litigation practices. We know another one like Jay Reisinger, a terrific sports lawyer in Pittsburgh who has developed a niche representing Major League Baseball players in legal disputes.
Yeah, absolutely. And usually these guys are known as like the fixers, as you mentioned before, and people that can come in and really know how to not only handle the lawsuit, but also get the right people in place to handle the public relations side of it, because that's really half the battle, is controlling the story. And we talked about earlier in the Mixkin case, this attorney, clearly on his attorney's advice, released this video well ahead of what everyone was expecting on a Friday afternoon. And that's all strategy. That's all trying to do the best for his client that he possibly can, especially, frequently these lawyers are put in pretty tough positions, obviously. And I think we discussed the other day about some interesting cases coming up. And talk about a lawyer in a tough position is Aaron Hernandez's lawyer, who's defending him on his second murder trial. And there was a pretrial hearing this week, and I'm getting way off topic, but the one of the witnesses said that he saw Hernandez shoot the guy, and so that's a tough one. We haven't had the ruling whether or not these witnesses are going to be allowed to testify, but assuming that they are, this lawyer is going to have a tough case ahead of him, especially considering he's already lost the one.
Yeah, I think I see a future for us as sports law crisis managers, Wallach and Worley, or Worley and Wallach. I think there's a need for that because there's some awful, first of all, there's so many legal battles involving professional athletes, and some of them don't know where to turn or may not be getting good advice. But I'm seeing strategies emerge. I'm seeing a common thread between a Derrick Rose case and, of course, the new one with Barnes and Cousins, the emergence of the sports law press conference utilized to accomplish an end in litigation. In the Derrick Rose case, the press conference was used to, summon public support and possibly leverage or pressure Rose's legal team into a settlement. And in this case, I think the press conference by the plaintiff's lawyers in the suit against Barnes and Cousins was motivated by a desire to keep the case in the public eye and keep the heat on the New York Police Department to maybe continue their pursuit and continue their investigation. Because while these plaintiffs, were in the aftermath of the incident, they had black eyes, they had telltale signs of being injured, and trotting them out at a press conference on the third or fourth day after the incident, I think was a brilliant maneuver, and it kept the story alive in the media and in the newspapers for several days when it might have just become like one of those 1 day or 2 day TMZ stories, and then people move on. So we could see a trend here.
Great point. Yeah, I think that's something that was new to me, especially in the Derrick Rose case when they came out and did that. I'm sure it's been utilized in other types of cases before, but in the sports context.
Yeah, Gloria Allred. Gloria Allred is notorious for doing that. But
right.
In sports law cases or cases involving professional athletes, we're starting to see this happen a little bit more frequently.
Right. And it was interesting in the Rose case, they brought in Joaquin McCoy, who was sort of a specialist in sort of these higher profile cases, and I think I would venture to guess that it was his idea to do that. And they brought him in the legal team way late in the game, and he ended up handling a lot of the trial. And so that was another strategic move that they wanted to do, the accuser in the Rose case. But anyway, we're getting a little far afield. Let's move on to the next topic, and that's I think my favorite name of the year, and that's WikiLeaks. I just found that to be a hilarious title. We've had some good ones. All the gates out there.
Walkie-talkie gate.
WikiLeaks I've seen now too.
What? WikiLeaks?
WikiLeaks, yeah. Which is, I think, a take on WikiLeaks. So, but obviously I think everyone's heard the story. A former player, assistant coach turned announcer for Wake Forest was giving confidential information, plays. We don't totally know the extent of what he was giving to other teams. We don't know how many other teams, but there's at least a handful at this point. And ultimately trying to give them an advantage in the games. This happened over a few-year period. Dan, what's your take on this whole thing? What is your thought on sort of what the litigation that could come out of this?
Well, I think looking down the road, a fallout from this, the victim of this, is going to be relationships between coaching staffs and media members cover the games. We often hear about Phil Simms or someone else talking with the head coach during the week, talking about the game plan. After this has come out with a radio announcer giving the playbook to members of the opposing coaching staff. If you think Nick Saban was paranoid and protective about his game plan, I think this case is going to shine a light or at least lead to even greater paranoia in the future, because what we're learning is the existence of a game plan is a trade secret. And in order to have a protectable trade secret, reasonable precautions and safeguards have to be taken to maintain the secrecy of the information. So now I can just imagine, general counsel for an NCAA school in the aftermath of this incident going over the protocols and procedures as to, who has access to the game plans, and maybe narrowing the list of people with whom this information is shared. So I think that's going to be the long-term fallout of WikiLeaks. In the short term, it raises the issue of how extensive, Tommy Elrod's disclosure of this information went. I mean, right now we're seeing offensive coordinators and position coaches bearing the brunt of the fallout, but this could be a Bobby Petrino issue as well. Because we do know, as a result of the University of Louisville's investigation, after initially trying to stonewall it, I think more recently the Louisville side has been much more cooperative in the investigation of the Wake Forest, and they admitted that their offensive coordinator, Lonnie Galloway, received the information directly from the announcer, Tommy Elrod. but that Bobby Petrino had absolutely no knowledge of it and disclaims any knowledge of it. And I find that, I find that a little difficult to believe insofar as think of what side of the ball that those coaches coach. Galloway is the offensive coordinator, but Bobby Petrino made his reputation as an offensive guru. And it does strain credulity, at least initially, to immediately discount any possibility that Bobby Petrino, who's very familiar with the offense and probably communicates frequently and more regularly with his OC than he does with his defensive coordinator in game planning, that he would have absolutely no knowledge. I think this does beg the question, and should the NCAA investigate this and should the schools release the results of an investigation? Because just to make an offensive coordinator walk the plank and pay a $25,000 fine to the ACC, I don't think that should be the end of the inquiry.
Right, and there's while we've been taping this podcast, another story came out that a current Georgia coordinator has also been fined $25,000 for his role while he was coaching at West Virginia. And West Virginia had been one of the schools that they talked about investigating, I think along with Army as well. And to me, I think one of the really interesting aspects of this that people aren't talking about is sort of how they found this information out. Apparently the opposing coaches left some notes behind either in the locker room or wherever, and the Wake Forest coaches read them, which, I mean, I guess, is that a normal thing? It doesn't strike me as a normal thing for coaches to leave behind their game plan and have the opposing coaches actually go through all of that stuff. So that was a little bizarre to me. You kind of have to wonder, that seems like a bit of an anomaly. Like, how long could this have gone on for if that wouldn't have happened?
Yeah. That's a really interesting point. I mean, how it was discovered, and I think it took a student to explain to the coaches what it was, what kind of information that this really was. But I'm somewhat skeptical that there's one person that takes accountability and falls on his sword for the good of, or to save his boss or a supervisor, and it's never any head coach who does the mea culpa. But in this instance, Lonnie Galloway did have the relationship with Tommy Elrod, but he wouldn't share that with the other members of his coaching staff. He would just keep that to himself.
Yeah, that's a stretch, I would say.
Yeah. So I don't think we've heard the last of WikiLeaks as far as the investigation or search for the truth is concerned. I think at the ACC level, it's a done deal with the fines. As far as the relationships between the different universities, that's probably a done deal. And they're sort of sister schools, part of the same conference. But I think the NCAA really does need to get to the bottom of trying to find out what happened and who else, if anyone, is a culpable party here.
Yeah, and I think it makes sense for us to kind of talk through the potential civil lawsuits that could come out of this. And I think, you were quoted in the USA Today. I know they had a story, they had a lead that the quarterback of Wake Forest's father was considering filing a lawsuit against Elrod, basically alleging that because he gave the plays away, his son may have gotten hurt, may have suffered more concussions, more sacks. And I think your point was a smart one, that the injury alleged here, that there may be some lasting damage to the quarterback, and then the action that alleged to have caused that, giving away these plays, is probably just too far separated. There's not enough connection there for liability in a civil suit. Yeah. Is that basically what your thought was?
Yeah, I mean, this is like Paulsgraf versus Long Island Railroad on steroids. Remember that case? Law school.
I try to forget all the cases I read in law school. It's ringing a bell. Yeah.
Okay. It's the concept of proximate causation and the and the multiple levels between the event that gave rise to the injury. And in this case, we're talking one that's remote, speculative, conjectural, I think maybe a reporter just sort of got the father to say, I really should sue, but I don't think any lawyer would be taking that case unless his son was in fact injured. And in the absence of the manifestations of any kind of a physical injury, I think it just made for a nice news story on one day. And I do appreciate you giving you were supposed to be the legal expert quoted in that piece, and you were unavailable for the story and were nice enough to recommend me to the reporter I think it was from USA Today or the Winston-Salem Journal. I forget which paper. So thank you. But in the end, I think it made for a nice soundbite on day 3 or day 4 of the scandal. But nothing's come of that. And here we are 2 weeks after WikiLeaks, and no civil lawsuits have been filed. Nothing from the father, nothing between the schools. I've read that the suspended coach from University of Louisville, Lonnie Galloway, lawyered up because he was suspended for the upcoming bowl game. But I would be really surprised if he sued his employer over that. And I'm not sure, much to our chagrin, I'm not sure that there will ever be any civil litigation arising out of WikiLeaks. I think this becomes an issue for the NCAA to address, and potentially a criminal matter for state or federal law enforcement in North Carolina. And we haven't discussed that aspect of it, but there could be several federal and state laws implicated here, criminal laws.
Right. And just to add to sort of the collection of facts, the Wake Forest came out and said that they consider this matter closed. I mean, that's obviously not a direct, they're not saying for sure we're not going to file lawsuits, but that's kind of the sense I get, is that they want to move past this. Obviously, if they filed a lawsuit, that there's some of the potential in discovery that bad facts about how they're monitoring their own announcers, other people in the system, are probably going to come out, could come out. And so,
that's a great point. Yep. I mean, think about it. They could win on a theory other than misappropriation of trade secrets and then have an adverse finding on the trade secrets issue because they didn't take safeguards or reasonable safeguards to protect or keep the information confidential. So they could win on a particular legal theory like theft of property, but then have a finding that their confidential game planning information doesn't rise to the level of a protectable trade secret. So there's really no big win here for them if they pursue this matter in the courts against their sister schools, or even against Tommy Elrod, who probably doesn't have the kind of money necessary to pay a judgment.
Yeah, and that was my next point, is that we look at these previous 2 cases which are in civil litigation right now, and you say, well, why do athletes get sued? Because they have deep pockets. And in this case, in WikiLeaks, Elrod, there's no indication that he does have deep pockets. He might, but not anything that I've seen. And so, what's the point of going through all the hassle to sue him and get a judgment when it's you're not going to be able to collect from that judgment? So I think the one issue there that I find interesting is that he was an IMG employee, and IMG certainly has deep pockets. But the issue is IMG can only be held vicariously liable if he was acting within the scope of his job duties. And I think it's pretty clear that he, at this point, was not acting in the scope of his job. He was acting as, something completely separate from his job in stealing and giving away these secrets. And so I think it would be a difficult argument for anyone to go after IMG. Not to say that they wouldn't try, but, if they're just going to go after Elrod, I just don't see a lawyer wanting to take that case against someone who just doesn't have any money in a judgment.
Yeah, Dan, what do you think ultimately his motivation was? I mean, one theory is the one that I'm tending to subscribe to, is that, he was a long-time coach at the school who was not offered to remain on the new coaching staff when the new coach Clausen came in last year and was moved to the radio side, and may have had an axe to grind, or may have been a disgruntled person towards the new coaching regime. But if it comes out that he was paid and received money, then I think that might increase the likelihood of civil litigation brought against him. But I would tend to buy into the disgruntled former coach theory than someone who is engaging in acts of commercial bribery. I mean, do you have any different theories about that?
I don't. I mean, my opinion. I don't know. I would say that it's revenge based. It seems like the facts line up.
Yeah.
To the point where, this guy, he's a player there, he's a coach there, and it's a dream job for him. And this new coaching staff comes in and says, sorry, which happens frequently, as part of the business. They were kind enough to seem to help him. That's what I've heard, at least. I don't know if that actually happened or not, but he got a job, obviously, as a radio announcer for the school, so he's still part of the program, but he probably, didn't take that too well and decided, well, I'm going to get back at this coach and maybe get back in. I don't know. Who knows? But that's the theory that makes the most sense to me. Another thing that's been thrown around, completely unsubstantiated, but is a gambling angle to this, whether he somehow had some sort of gambling set up where he was betting against Wake Forest and giving away trade secrets that would help them lose, and maybe lose by more points. But I haven't heard any evidence of that yet. I haven't heard any evidence of him getting paid out.
Nope.
But those are things that, to your point, I think if either of those facts came out through an investigation, that this really changes the dynamic of this story from maybe a criminal and civil perspective as well.
Yeah, I mean, I can think of a number of laws that might apply. You're getting into the area of sports bribery laws, federal, state, and I think there would be a sense that he stole from the university and and benefited from it financially. So I think the university might become less sympathetic towards him if it became if it was discovered that he received money. And I agree with you. I mean, you and I don't know for sure, but this does have all of the hallmarks of, as you described it or coined it, revenge based. And if that's what it was, I mean, what he did was horrible. He's never going to work he's not only not going to work in college athletics again, I don't think anyone in athletics at any level would hire him to do anything. So he is paying, and deservedly will be paying, a steep price for his transgression. But as long as he wasn't paid or receiving any other financial benefit from the coaches that he gave the information to, I think the school will just let it lie with him and not pursue him judicially.
Yeah, I think that's probably the most likely outcome as well. And that leaves us with our last topic today, which has been another huge one in the news. That's the University of Minnesota situation that's happening. Just as a brief background, there was an alleged sexual assault that took place at the University of Minnesota, I believe in off-campus housing, and a female University of Minnesota student alleged that a group of men, at least many of which were University of Minnesota football players. One was a potential recruit that was a high school student that was visiting the school, raped her, and ultimately the school, there's no criminal charges filed. The school conducted its own investigation and found that a handful of these players violated school rules and were kicked out. And after that happened, the rest of the Minnesota football team, or they were at least suspended. I don't think they were kicked out yet. I can't remember the details. But the rest of the Minnesota football team just announced they were going to boycott the game until they got a better explanation of what happened. And a few days after that, they were given this 80-page report. I read the 80-page report. I'll warn you, I usually tell people to read the source documents. This is a particularly disturbing report, so just keep that in mind. I encourage you to read it. I have it posted on my website, The White Bronco. I have a new feature called The Docket. You can see a tab right at the top. If you click on that, you can find that report on my site. And within that report is a pretty graphic detail of the accuser's side of the story, as well as some of the other evidence obtained by the police and throughout the Minnesota investigation. Once the Minnesota players who weren't involved in the assault but were involved in the boycott read that report, they immediately announced that they would play in the bowl game, and they said that they supported both the accuser and the accused, and they hope that they all get fair and due process. So the boycott obviously came under fire. It seemed like the players were defending sexual assault rather than defending due process, because that's really the optics of a case like this. What was your take of when they made the boycott, Dan?
Well, I think it all turned, the momentum for the boycott turned on a dime the moment the players admitted that they hadn't read the report. And of course, what happens next? The school starts leaking the report to the press, and then it's all over. So another big loss for athlete activism. But there's some battles that are worth standing your ground for. A woman being, allegedly gang raped isn't one of those that you make a stand on. This wasn't the issue, and I think once the players, became aware of the severity of the accusations, they struck a more conciliatory tone, because how could they not? To have done otherwise would have shown, grave insensitivity towards victims of domestic assault. And you don't do that in 2000. You don't do that at any point in civilization. But in 2016, that's not a public relations war. You should even try to strike up. So the players were boxed into a corner once they admitted they hadn't actually read the allegations.
Right. And again, I think, we won't spend too much time on this case, but I think a few of the possible interesting angles moving forward from our side are what are the potential legal fallouts that happen here. And, you've seen cases of sexual assault where there's Title IX lawsuits filed against a university. Those cases are based on the university not addressing the complaint of the sexual assault, and I don't think we've seen that set of facts here, so that's not something that I would anticipate coming from her side. But I think something that we might see potentially is, as we've discussed above, a civil lawsuit for the sexual battery, as it's usually called in state law, and the only issue there, as we discussed too, is whether this victim would want to pursue a lawsuit, and whether it would be worth it for her, whether or not any of the proposed alleged defendants, would have deep enough pockets to make it worth her while. And I don't know much about the accused, I should say, but I know that one of them is the son of an NFL player, so that is something that could factor in. And so those are just a few of the things that popped to me moving forward.
How about, Dan? How about a theory of enterprise liability here? Did the attack take place as part of an organized recruiting visit, or during an organized recruiting visit?
It did, yes. And so this is detailed pretty well, at least alleged pretty well in the 80-page report. But the initial incident took place with a player and a recruit, and they brought her up to the player's room, and she allegedly had sex with both, and the player actually kind of locked the recruit and the woman in a room together with seemed like some sort of expectation. Mm-hmm. There's even a quote in there from the recruit saying that this place is so screwed up, I'm not going to go here.
Oh my God.
And because of this incident, and so I think the recruit angle really brings another interesting point beyond this enterprise liability, but I think it could bring it into the NCAA violation realm as well.
Oh yeah, I'm thinking like a plaintiff's lawyer as we're learning that this is part of a recruiting visit, and the players that are serving as the ambassadors or representing the school and squiring the recruit around campus, showing him a good time. We could be talking in the realm of negligent supervision. There could be a multitude of tort theories, and of course you're going to sue the school. I just didn't know that the fact pattern was lined up the way it was to maybe have a viable legal theory against University of Minnesota, and it sounds like it could be a possibility.
Yeah, maybe. I'm trying to think through that. Would the woman have standing there, or would the recruit have standing? Because just trying to think through if the woman could make the link to the university. I think it's probably a stretch, but I think you make some good points, and that there might be something out there. And again, we don't know all the facts. We know a lot of the facts now. There's also apparently there's some video out there. It has not been released, but the police had it, I believe. And, there's some questions. There's obviously alcohol involved. I shouldn't say obviously, but there was alcohol involved here. So that's also something that's at play. So there's, again, I think there was some question of a consent issue, at least at some point. Reading the allegations, it's hard to think that, at least through many points of this whole thing, that there was ever a consent that it appeared to me that there clearly wasn't consent. But I think
were locked into a room together.
So that was just the beginning. It gets much worse than that later on when more people are involved. But I don't. It's too graphic to really get into. If you want, you can read it. But
Dan, does it seem to you that stories like this are multiplying rather than becoming non-existent or relics? Are we just paying more attention and we have greater sensitivity towards victims of sexual assault, or are the lessons of past cases not being learned by athletes or universities? Because I see no abatement of this kind of despicable alleged conduct. It just seems, from one month to the next, there's like a news story, a new college that's emerged as an issue. Does it seem like it's getting worse, or is it just better reporting?
Yeah, I think it's a number of things. It's funny you say that, because today there was a University of Michigan football player was arrested on a couple misdemeanor counts and a felony count for groping a woman and then running from the cops and allegedly breaking a cop's wrist, and another potentially ugly story coming out. Nowhere near as bad as this Minnesota thing, but just another news line for the month. But I think it's a few things. I think there's a greater awareness. I think there's better reporting happening. If you read, there's a couple books that I would recommend to our audience that I think would show that this has been a problem for a long time, and that we're just probably learning more about it and really having a greater awareness of what's happening. And the first one by Jessica Luther, called Unsportsmanlike Conduct. And that does a real good job of recapping the history. I mean, it goes back years and years to a number of incidents that's happened. It's incredible reading that book and then looking at the sports landscape now, and you see players that were involved, coaches, administrators. It's a much wider web than you would think. So that's a good one. And then also there's a book called Missoula by John Krakauer, who's one of my favorite authors, which more specifically, it talks about sexual assault by athletes on campuses, but more specifically talks about one university in general. And so, having read those and just kind of getting this more into my mainstream thought process in the last probably 24 months, it seems really like the difference isn't that it wasn't happening before, but it's the media is covering it more now, and we're learning. We're doing a better job of covering it and a better job of being aware about it. I would hope that because of that at least from this point on, that schools will do a better job with education and other ways that we can start preventing these things from happening. But unfortunately, it seems like to your point, that they continue to happen, and it's sad.
Yeah, I agree with that. I also I look back. Well, what changed, or what was the catalyst for this intense, increasing scrutiny on college athletes? And I look. It's obviously the Penn State case, Joe Paterno and Jerry Sandusky. I think that I think as the media and the public, with the exception of the Penn State campus, I think we all changed our perception of how to treat, sexual assaults occurring, within the confines of an athletic program or affecting an athletic program. I mean, it was always in the school's best interest to bury a story, or to make it go away, or turn the other cheek, or pretend it didn't happen. But after Penn I mean, those days are over, and I don't see these lessons being learned by Baylor or Bears. What goes way back in time, but it just seems as if we're going to have another one of these campus rape cases or rape claims made involving a major college athletic program. I mean, they're just too they're too recurring, and it's disturbing.
Yeah, I think the Penn State certainly impacted it. And the facts of the Penn State case were obviously an outlier. They're kind of off the pattern of these other cases. But if you look at, I think the Jameis Winston case caught a lot of public attention. And I think it's worth noting that this past week, maybe 2 weeks ago, that Jameis Winston finally settled his civil lawsuit with his accuser. And so I think all the legal action from that incident is finally closed. And that took place 4 years ago. So, it shows you how long these things take to wind down. And he wasn't even going to go to trial until the middle of next year. And then you look at how that case kind of tails into Baylor. And Baylor's obviously gotten a lot of public attention. And I think that schools and I think that athletic departments should be worried about this. I mean, I think it goes beyond athletics, obviously. This isn't just an athletics issue. This happens at schools in different ways. I forgot the Duke one as well. I think that was another one that hit the public eye pretty hard, the Duke lacrosse team. But this, I think this is something that you're going to see. It's a nothing good comes out of this, but
yeah, I mean,
it
affects it affects their business. I mean, it has a negative impact on applications to the school. For so many years, and it happened in the Jameis Winston case. I mean, they were exalted as athletes on campus, and there was no such thing as accountability or real investigation. He walked on water at Florida State, never paid any kind of a price in discipline when he was accused of a serious sexual offense. And part of the problem is that sports or Division I big time sports are exalted at these programs, and there's a disincentive for the schools to rein in these athletes because it's more important to have a winning program, to bring revenues into the pipeline. You don't want to kill the golden goose, but at the same time you could be doing long-term damage to your brand as a college.
Right. And talking of the bottom line, you just see how these things can kill a program is even when there's no quote-unquote death penalty from the NCAA or some huge penalty, you look at Baylor's recruiting class this year, and as of, I haven't looked recently, but as of, I guess, a month ago or so, they had 0 or 1 commit. And at this point in the recruiting cycle, schools have up to 25 at this point. They're almost full, and Baylor basically has no one that's willing to go there. And so from a talent perspective, which ultimately leads to a winning program, which ultimately leads to revenue for the schools, these type of things will kill a program. And so I think you're going to see the repercussions at Baylor for a long time. And I think it also, I think they're probably having a tough time hiring a coach. Did they hire a coach yet? They did, right? They did hire a coach, but I'm sure it wasn't their, first or second choice, because what coach in their right mind would want to come into that mess right now? And there's obviously the NCAA penalties looming over their head potentially, and just so many other issues. So, but we'll see.
There's always a young coach, Dan. There's always a young coach willing to take an opportunity. I mean, in the ashes of the Penn State scandal, which was a horrible situation, Bill O'Brien comes in, rehabilitates the program, embellishes or raises his own profile and reputation, and then he goes on to the National Football League as the head coach in Houston. So I think there's always going to be a willing up-and-coming, an up-and-coming coach who wants to raise his profile, because if you can go into a Baylor that's sort of on, in the ashes and in a state of disarray, and you could win there, it just positions you for the next job.
Yeah, that's a good point. And obviously, O'Brien wasn't afraid of the NCAA sanctions that were out there at the time. And you could say the same with James Franklin, who came after him, because O'Brien was only there a year or two. So it's something interesting to follow forward. My overarching point was that I hope that we have a better education, hope we have a better awareness of this. Obviously, there was some issues at Baylor, for example, of them taking transfer students from other schools who had a history of sexual assault, who then also had sexual assault issues at Baylor, which is horrible, obviously. And so that turns into sort of a purely talent move, and that's just not a good way to do things. Not to say that no person should ever get a second chance, but the way that it was handled was not good. And so, the hope with this case and other cases is that we learn and hopefully do better. And I think that that's sort of the moral at Minnesota too. The players, I'm sure, learned a lot about their actions of making this boycott and what that really meant and how they were viewed in the public, in the media, by their peers. Yeah. And I think I saw some of the speech given by one of the players after they decided to end the boycott. And, he was an impressive kid. And, I think that whole program learned a lot and hopefully can move forward with this thing.
Yeah, pick your battles wisely, and I think the players at Minnesota obviously were misinformed, and that wasn't the battle to really go to the mat on. It really wasn't, and they obviously learned quickly enough about the severity of the situation. But hey, it's the end of this year, but not the end of more controversies on campus. I am sure 2017 sadly will bring more of these horrible stories, because whenever you have kids on campus and you have a culture like that, it is inevitable that this cycle will just keep spinning.
Exactly. And with that, I think it's a good time to wrap this up. As we mentioned, we're going to have a podcast, maybe multiple podcasts that are going to wrap up this year and sort of preview next year. Dan and I are going to be hard at work over the holidays.
No rest for us next week.
Right.
I think we're trying to end 2017 in a bang, and we hope to be able to announce several special episodes to wrap up 2017, but we're still working on it. But anyway, Dan, this has been, for a penultimate episode, I'm amazed that we made it this far and have kept the pace and have kept the continuity going, 10 episodes in. It's been a great year, and I wish you and your wife and your family a Merry Christmas, and just it's been awesome getting to know you and working with you on the podcast and on other stuff as well. And I look forward to much more of this, not just next week, but well into next year in the future as well.
Absolutely. Merry Christmas to you as well, and Merry Christmas to people listening to. And
for Jews, it will be Chinese food and movies on Christmas Day.
Right. Well, there you go. Everyone, thanks for tuning in again. We really appreciate it. If you have feedback for us, you can reach Dan Wallach on Twitter at Wallach Legal. You can find me at Whirly Sports Law or at the White Bronco. We appreciate iTunes reviews, ratings. If you guys have things you want to hear or things that we're not doing well or doing great, we'd love to hear that. Feel free to shoot us an email, shoot us a note on Twitter. All of that is very appreciated. We've hit 10 episodes, and we're trying to find our stride and what works best and what doesn't, but your feedback is extremely appreciated. So thank you, and happy holidays to everybody, and we'll talk to you soon.